Good afternoon, everyone, and thank you all for joining today's California employment law update for you and all of you hoteliers. As most of you know, my name is Arti Soma, and I work with a lot of you hotel owners and operators on employment and wage and hour issues, including litigation issues, ADA, compliance matters, really anything that your hotel needs. Today's presentation is designed specifically for you guys and your management teams. My goal today is not to overwhelm you with every employment law development in California, but instead I want to focus on the issues that are most likely to really create real exposure for your guys' hotels, especially when it comes to day-to-day operations. As you all know, California law, it can get really complicated, but hotels really have additional pressure points because you guys are the ones operating around the clock with different departments, different classifications, different wage rates, and there's often a lot of turnover when it comes to your guys' workforce. And so little disclaimer, this presentation is there to be informational. It's not necessarily legal advice for any type of specific situation. And if you guys have specific questions, I'm happy to answer them for you at the end. Feel free to chat them so you don't forget them. But by the end, you should have a practical checklist of what to review over the next 90 days so you have an action plan going forward. Today, we're basically going to be covering really wage and hour updates because frankly in hotels, that's where we see the fastest and most expensive liability. This is going to include, statewide, local minimum wages, exempt, non-exempt. After that, we'll move into our 2026 notices, record keeping and leave obligations. Then we'll cover immigration, I-9 enforcement. We'll also discuss heat illness prevention as we get into this summer. And then we will talk really about AI in the workplace and how we're seeing that when it comes to surveillance and possible litigation exposure when it comes to our guests and our employees. And then we'll go ahead and end with our 90-day compliance checklist because I want you guys to be able to walk away with having some type of step-by-step plan of how to address everything that we're going to discuss today. The first point I want you guys to remember is, hotels are not a simple workplace. Hotels really where a lot of things are operating at the same time, right? We're juggling so many different plates. We have so many different departments that we're dealing with, whether it's front desk, housekeeping, maintenance, laundry. Some of you guys have larger properties where I know that you have, valet, security, food and beverage management. And so there's a wide array of different problems that you might be experiencing in different departments that you need to juggle, right? You might have housekeeping that have to take their rest break or overtime when they have high occupancy. You might have your front desk clerks that need to be able to take their lunch break, but they can't leave the desk because they're the only person there at the front desk. And so because of all of this, it's what makes hotels really uniquely vulnerable to these type of repeated employment law mistakes that we keep seeing. And frankly, it makes it the biggest liability, which is not usually one big dramatic event that's going to happen, but what it really is these small events that once one time it happens and it repeats across the board, then it can have big exposure. For example, let's say that you missed a meal premium that you were supposed to pay to an employee. It might seem small, but if you use that same model across all of your employees, and now it's happening over multiple days, weeks, months, years even, it can be a really huge wage and hour claim eventually, and you're going to see a class action and a PAGA claim coming against your property. The same is true for when we see, local minimum wage errors, incomplete I-9 forms. So really the takeaway, it's pretty simple. The idea is that hotel compliance, it's not just about what's written in the handbook, it's operationally as well, and what you guys are doing on a day-to-day basis. While it's important that you guys all have written policies in place, and please make sure that you guys have employee handbooks, the real question is are you adhering to those, and what's practically happening on the property on that day-to-day basis? So those of you that joined us in January of 2026, you know that California statewide minimum wage increased to $16.90. Our next slide is going to be going over what those different increases look like coming up on July 1st for different localities and different cities. But this is the minimum floor that the state is mandating that needs to be followed. It's really important that you guys are, one, classifying your employees properly. The reason why is there's a difference between how you should be classifying your hourly employee versus how we are classifying our salary employees, right? And the idea is that a salary employee must be doing at least 51% of managerial duty tasks, or we say exempt level tasks. So if those of you that have your managers, running the front desk 80-90% of the time, unfortunately, that's not going to be sufficient to meet that criteria. And you should really be paying that manager that's running the front desk as an hourly employee and not a salary employee. Otherwise, what's going to happen is, let's say that employee has been there for 10 years. Now he can later on bring a wage and hour claim against you, and you'll have to not only pay them whatever that minimum wage was at the minimum for each of those times that they were working, but also now interest on top of that. And then likely they missed, their lunch breaks and their rest breaks because you were thinking that they were just a regular salary employee and weren't monitoring that, when they should have been, getting their proper breaks at certain periods of times. This is just a general snapshot of, some of the major areas that we know, like Los Angeles, Santa Monica, San Diego, Glendale, Long Beach, to see some of those wage increases. And then in some of the other areas like San Francisco, Mountain View, Sunnyvale, I highly recommend that each of you, if you're not seeing your county, or if you're not seeing your city on here, please go ahead and look it up just to make sure that there is not a particular increase. You can also shoot me an email. My email's in the bottom right corner, and I'm happy to go ahead and send you all of the increases that are going to be happening in all of the different cities and locales within California. It's a really big PDF, so I'm happy to send that as well so you can double check that you're not on there. But it is important that you let your payroll companies know that you are matching and meeting this minimum wage starting July 1st, so that you are paying your employees properly. The idea is that this is an automatic thing. It's an automatic wage increase. And so if they are making below that, right now, it needs to be an automatic increase that you are giving. This is not an optional item. This slide is really covering the recurring wage and hour traps that we are seeing within hotel operations. The first is off the clock work. This can happen very simply and easy, right? Your employee comes to work, but before they clock in, they're going to pick up their radio. They're going to grab their master key. They're going to put on their name tag right before they clock into work. All of that is what we call pre-shift items. And technically, some of these items can actually fall within, working and on the duty work. And so the best practice here would be making sure that you tell your employees to make sure they clock in before doing anything, right? Before they answer a question for another employee, before they go and get, some of those uniform items like their name tag or their radios or their master keys. So very important that you, one, tell your employees to keep on reminding them. And I like to put a notice right in front of the time clock as well. Before starting any work, please make sure to clock in. The second is interrupted meal periods. A lot of times, hotels are put in this vulnerable situation where it's not intentional that we give our employees an interrupted break, but it just happens with it being the trade of the business, right? You have your front desk employee, they're maybe the only person there at the front desk. We want them to be able to take their lunch break, so we tell them to take their lunch break. All of a sudden, they start eating, and then the phone rings, or a guest comes, or, something happens and it brings their attention back onto work items. So that would technically, even though they were taking their lunch, it's not really considered legally compliant, right, in California, because it needs to be at least a minimum of 30 minutes and fully uninterrupted. And so the best thing that you can do is have some type of, if you do have an FOM or you do have a GM, have them give that person off, relieve them, allow them to take their 30 minutes, make sure that they're clocking out for that 30 minutes so you do have that punched. And if you don't have anybody that can relieve that person during their shift, then you just need to bite the bullet and end up paying that extra meal penalty, which is an extra hour of work that you would pay them for that shift. The third is missed rest breaks, right? A lot of times we're seeing this in housekeeping or in laundry, and we're seeing this really happening during high period occupancy times. There's a lot of pressure that we put sometimes on our employees to finish rooms or to complete loads without real rest breaks. And so you may end up having to then owe them, again, one of those extra hours for a missed rest break. So it's important that, we are giving our staff the 2 10-minute required breaks that they are allotted. They don't need to necessarily clock in and out of it. But what I like to say is before they get their paycheck, on the biweekly basis, you have them sign something, right? Saying that I got all of my lunches and breaks during this period. And that way, in the future, if you ever need some type of backup or documentation, your time clock might not be working because it doesn't have those breaks. But of those papers, right, where they did admit that they did take all of those breaks. And then later we use that as a defense for you saying, well, why did they sign this paper acknowledging they took their breaks when you're claiming now they didn't? The fourth is rounding and grace period practices. I don't see this all too often, but unfortunately, I have seen it recently in a couple of cases now, so I just thought it was important to bring up now. Sometimes our time clocks, they like to round times. Unfortunately, it's not rounding time in favor of the employee, it's rounding time in favor of the employer. That can become a really big class action issue, even if it's just small amounts of time. So important to just make sure you're checking your settings on your time clock to make sure it is not, rounding up or rounding down. Make sure that it is properly marking the times that are getting marked in there. And then the fifth is false exemptions. So I talked about it a little bit earlier when we talked about hourly and exempt employees. Unfortunately, I have seen way too many cases this year than I would like to when it comes to our favorite resident managers, right? These are people that we're having stay on property and we're giving them the title of manager and we're paying them a salary and maybe deducting some money for the place that we're giving them to stay on the property, but really they're not doing managerial work, right? What would we say managerial work is? We're thinking things like checking the rooms, checking payroll, working on guest reviews, right? It's okay here and there to help with the front desk, but again, we look at that percentage scale. 51% of their work needs to be managerial tasks, while 49% can be things like running the front desk if and when necessary. But it's important, if you have somebody that's working the desk 40 hours a week, that's not a manager and you should be paying them technically hourly wages. There are ways essentially to get around that if you need. Happy to discuss that and talk about that offline a little bit more. Again, reach out to me and we can kind of talk about alternative solutions where you can still make that situation work, but make it, legally compliant. The best practice really at the end of the day is for you guys to audit your timekeeping systems, compare it to written policy, which is what's in your actual handbooks, and make sure that that's actually what's happening on the property on a daily basis, right? Don't just check whether your handbooks are compliant. I know a lot of you guys send us your handbooks to draft and we draft them, but how many of you guys are actually, reading through it and making sure what's in your handbook is actually the policies that are getting followed on a day-to-day at your property, right? Not too many. So it's important you look at that written handbook, look at what's happening on the property, and make sure those things are matching at the end of the day. This slide is all about the difference really between our federal guidance and our California law, right? We have two different types of laws here in the country. We have federal law, which is over the entire United States, and then California creates their own laws, which we call state law. So the Department of Labor, they recently issued a bunch of these opinion letters, and they address issues like meal breaks, pre-shift work, exempt employees who perform, non-exempt tasks. And that federal guidance, it can be helpful, right? Our California law enforcement, our judges, they look at these rules. But unfortunately, we know California is a very, very, very employee friendly state. And so, more often than not, California laws are a lot stricter than the federal law. So, for California hotels, the key question is really whether that employee is truly relieved of all of their duties. If the employee is working and available to guests, interrupted by supervisors, answering phones, or handling any type of guest needs during their meal period, that time should not be treated as an unpaid duty free meal break. We talked about that again earlier. I can't stress that enough. It's 100% actually. I have always seen this on an employee demand letter. I have never not seen it on an employee demand letter where, it says that the employee was not receiving their lunch breaks, they were not seeing their rest breaks, or at the very least, they were not interrupted. Most of these examples you guys know of, but, this can include employee like clocking in early, right? And they're clocking in because all the housekeepers start maybe at 9 a.m. And they're like, okay, well, if everyone starts at 9 a.m. and we're all going to have to punch in, then I don't want it to get marked at 9:02 or 9:03. So I'm going to punch in at maybe 8:57 or 8:58. So once that employee punches in, you got to start paying them from the time they punch in and start doing that work, right? So if they punch in at 8:57 and start doing work, then you do need to pay them. You can't just round that up to 9 just because that was their normal shift time. Another example would be like if your front desk employee, again, is eating behind the desk, but they answer any phones, they cut any keys, they deliver something to a room, all of those things have to get paid for. It is not considered an uninterrupted lunch break. So please, please, please be mindful of meals and rest breaks that you're giving to your employees. This was already a rule starting in January 1st, 2026, except I know a lot of you guys are not following it, so I wanted to remind you guys about SB 513. It's all about record keeping, right? If we are training our employees or educating them in any type of formal way, this could be a housekeeper that we're teaching how to make a bed. This could be a front desk clerk that we're teaching how to use our PMS system. We have to document, and file that documentation in that employee's record. It's not just writing it on a piece of paper and putting it in there. Unfortunately, now there are specific things that we need to include within that document. I'm happy to provide you a free template of what needs to be included in that training log. Again, reach out to me. Let me know that you want a copy of that, and I will include it for you and send it to you. But those of you that want to create your own or double check that your log is compliant, you just need to make sure it has your employee's name on it, the name of the trainer, the date the training's happening, how long that training happened, what core competencies were hit and covered during that training, and were there any certifications or qualifications that they earned during that training, right? All of you guys should be doing trainings on a regular basis for your employees. There is a list of ones that need to happen annually, biannually, semi-annually. So please reach out. Happy to provide you that list as well. Some of these trainings should be, right, harassment prevention training, safety trainings, heat illness trainings, OSHA trainings, security procedures, workplace violence procedures. So unfortunately, California has a bunch of trainings that you are required to give, and you now must document that you actually are training your employees in every single one of those items. So please make sure if you are teaching a new employee anything, it needs to get documented and it needs to get put into their employee folder. Another one that, we touched on in January, it's very important, this was due March 30th of 2026, is you were supposed to have provided the state notice to each of your employees when it comes to their emergency contact obligations. You should have allowed them the opportunity to designate an emergency contact. And then for any new hires, you should be providing the same documentation to them. And now here's the caveat. This notice needs to be given every single year to your employees. Doesn't matter if they are a new hire, doesn't matter if they've been there for 10 years. Every year now, you need to make sure you're setting a calendar invite and you are providing this notice to your employees. And what this notice is saying is basically if you are arrested, if you are detained, we are going to contact your emergency contact. But we can only contact that emergency contact if you provide us their contact information. So now here's a blank form for you to fill out their contact information so we know who to contact. This should already be a part of your onboarding document. So please make sure you are taking a look at your onboarding documents. Make sure your HR is aware. If you do have an HR department, it's important that this is going out with your hires. And a lot of times we may think, it's a small document, it's okay, but it's just that one instance, right? That one mistake that we make where if an employee gets detained or if they get arrested and now all of a sudden it becomes this big issue. So better to be safe than sorry. Get prepared now. Make sure you're adding it to your notice packet for any notices you need to give on an annual basis. Make sure you're checking it on your onboarding documents and make sure you've given it to all of your employees up until now. If you haven't, don't worry, don't be too concerned. Just immediately go ahead and give it. This notice you can just Google, frankly. It's in English and it's in Spanish online. If you have trouble, I'm happy to provide you a copy of it as well or send you the link. But this is just a notice that the California state created. Just go ahead and type in SB 294 and you'll be able to find it. I-9 compliance. This is only important because it's now becoming a higher risk simply because ICE has basically expanded what is now being treated as actual errors and omissions rather than what used to be categorized as technical errors. So basically on your I-9 form that your new hire fills out, you just need to make sure that they really are filling everything out, right? Because any type of things now that are missing or that are erroneous, you can essentially now be penalized for that. So the errors to really look for include missing employees' date of birth, missing signatures, incomplete employee attestations, if you're missing, your employer's name, their title, the date that they're starting employment, making sure that that ABC document is fully filled out and you have proper verification. So you really want to make sure those I-9 forms are being filled out thoroughly from top to bottom. And the best thing that you can do is to just do an internal audit, right, of all the I-9 documents, make sure everything is filled out. Again, it's okay to go back and fix things, right? We don't want to get caught later on by ICE or caught by the government or caught by your employees when they file a lawsuit against us. It's better to go and take a look into everything now, the employee files, the time clocks, everything, rectify the issues now before it becomes a bigger problem later on. Okay, so this summer is going to be one of the hottest summers, if not record beating, because it is an El Nino year this year and next year, which means it's going to be very, very hot. You guys are supposed to have a heat illness prevention program put into place at your hotel. So you want to think about the employees who are working outdoors or in any type of high temperature area, right? This is going to include your maintenance employees, landscaping, pool attendants, if you've got valet, security, anybody working in the kitchen, mechanical rooms, right? For outdoor work, California's heat illness rules, they do require that you provide fresh, cool drinking water to your employees. Make sure you have a shaded area for when temperatures exceed applicable thresholds. Make sure that you're giving them cool down rest periods. This is in addition to the 2 10-minute breaks that you are giving them. Make sure that your supervisors are aware of the policy when it comes to the heat illness prevention. And then make sure you have emergency response procedures, right? What happens if somebody is presenting signs of dehydration? What happens if somebody faints? What are you going to do in that instance? Make sure that the water is included in a reasonable area, right? It should be close to the work area, and it should be something that is continuously available. If you don't have any type of water dispenser you can give, you need to at the very least ensure that you have 1 quart of water per employee per hour available. So if you wanted to buy cases of water, you can, but that is your formula there. You guys, employees must also be allowed and encouraged to take those cool down rest breaks. So you got to make sure you share that with them, that if they do need to cool down, they are allowed to take these additional breaks. And make sure that your supervisors, make sure your housekeeping supervisors are not discouraging them or telling them, no, you can't take these breaks. We've got other rooms to clean. We've got to get this fixed. It's important that we are putting our employees first. And so please make sure everybody is trained. AI. It's now becoming an employment law issue. Many hotels are already using AI without necessarily calling it AI. Sometimes AI is built into our training systems now. Sometimes it's put into our employment software that we're using to hire our employees, in our scheduling tools, in our productivity tools, or your manager is using ChatGPT and putting a question in there. The issue when it comes to AI is it can influence employment decisions, right? Even when a human is technically the one putting it all in there and making that decision in the end. A lot of that high risk is usually going to be, ranking resumes or recommending schedules or assigning shifts. And so California regulators, they are increasingly focused on automated decision systems. They are working on, coming up with approaches when it comes to implementing new laws for it. We like to put a little disclaimer in handbooks saying that although AI software may be used, at the end of the day, the final decision will be made, by a human being, and that the AI will not have any type of influential decisions when it comes to that. A lot of times it's important that you are not allowing AI to be the sole basis for your decisions, especially when it's materially affecting an employee and that employee's relationship with the property. You must train your managers, please, to not put any type of confidential information into AI. Don't be putting things like come up with a legal strategy or somebody's medical information or disciplinary information, because that could essentially be used against you, right? And that's what we're jumping into here. AI really is changing litigation. It's changing how we are seeing things and how we are doing things. And the two biggest issues that we are seeing is, number one, your AI chat history can now become evidence. Courts are beginning to address whether the prompts that you're putting in and the outputs, right? So the answer that ChatGPT is giving you, whether those are actually going to be discoverable or even protected in the event that your employee now files suit against you. It's not a black and white decision. The decisions are not uniform across the board. And so that right now means the decision is wholeheartedly up to the judge. And so you guys need to just assume that the answer is always going to be yes. You may be subpoenaed for that information. And so it is important that you are realizing what you are actually putting into your AI and realizing it may be discoverable in the court of law. Second, and this is a fun one, we are seeing hotel guests, we are seeing employees, and we are seeing former employees now using AI to draft demand letters and complaints and motions and charges. And this is starting to increase, unfortunately, defense costs on our clients, on you guys, because now filings are going to be longer. It's going to be more aggressive. It's going to be filled with legal arguments. It's, we've got to defend you guys against sometimes these things that are unfortunately baseless. And it's just being created and perpetuated by AI. Now, there are some defense opportunities, right? Unfortunately, AI is not perfect just yet. And I say just yet because it's going to get there eventually. But AI is not perfect yet, right? So we are seeing misstated facts. We are seeing inconsistent timelines, unsupported legal conclusions, unsupported legal citations. And sometimes when we are seeing that within the actual document, we are able to fight that in court. We are able to bring that to the judge's attention. In those events, we're able to get those things dismissed, and sometimes the entire case dismissed. However, the biggest thing you need to understand is employees now have a bigger way to essentially trap you, right? We're seeing more formalized emails coming from our employees. They're trying to build a record. So it's really important. You guys, I like to say crossing my T's and dotting our I's, really following the law, especially when it comes to dealing with our employees in California. California's pay transparency. Please note this only applies to you if you have 15 or more employees. Again, this is already a law that was enacted, but it's important that you guys are actually following it. If you are posting a job, you need to make sure that you post a reasonable pay scale range, right? This is something that in good faith you are providing this wage. So you can no longer say you're going to be offering $18 to $35 for your front desk clerk, unless in actuality you are really going to pay up to $35 an hour for your front desk clerk. So don't just simply copy and paste your old job postings. Make sure the posted range, matches the actual range that you expect to pay at the property. Based on where we're at right now in 2026, the workforce is just simply aging. And because that workforce is aging, it's creating really important compliance issues for you guys. A lot of times employees may be working now longer, including, physically demanding positions like housekeeping, laundry, maintenance, which requires them, to bend down, requires them to do a lot more repetitive movements, requires them to use their back and their knees. And so the risk is not only age discrimination, but it's an overlap between the age and disability and medical restrictions and leave rights and workman's comp and everything else. So it's really important that your supervisors are avoiding using, we like to say coded language, right? And what does that mean? Sometimes we have colloquial sayings or slang like, hey, that guy is like so old school, or he seems like he's ready to retire, or he can't keep up anymore. All of those lead to an age discrimination claim. So super important, we are minding what we are saying, minding those words. Sometimes we might use it as a joke, right? Can't teach old dog new tricks. When we say these things, unfortunately, they can have later really dire repercussions later on. So really important that you are consistently applying your performance standards across the board. Remember, you technically are required to provide reasonable accommodations to your employee if they do reasonably need it. In the event that an employee asks for that, you should be engaging in the interactive process with them. So set up a sit-down meeting with them, talk through it, reach out to us. We're happy to do free consults with you if you need. Evaluate the restrictions, evaluate the essential job duty functions, and then see whether that accommodation really is reasonable. And that brings us to the end of today's presentation. The main message, if I could choose one of any, is I want you guys to leave with employment compliance has to be practical. And it has to be property specific. While a great handbook is important, it's just not enough. You need to be compliant across the board in all your different fields, right? We're talking payroll settings, training your managers, employee files, clean I-9 records, employment documents, and all of these things need to actually match California law. So I recommend that all of you use 90-day checklist. I've put a little snapshot of one here for you guys today. And it really starts with the issues that are most likely to repeat across the board against all of your employees and all the different payroll cycles. Those of you that want a copy of today's presentation, feel free to shoot me an email. Feel free to scan this QR code. I'm happy to provide this to you if you have any questions. Now is the time to throw it in the chat box and ask. Otherwise, if you want to directly email me, I'm happy to answer your questions there. Those of you that wanted copies of some of those documents I talked about, email me. I want to be a wealth of information for you guys. Otherwise, thank you all so much for joining me today, and I hope you have a great one.